Our first case, Forrest versus Sigmapharm, is Hatch-Waxman litigation in which 5 generic drug companies who seek to manufacture competitive versions to Forrest's branded drug allege that the patent covering that drug is invalid as obvious, too trivial in advance over what was previously known to warrant patent protection. After a bench trial, the district court upheld the validity of Forrest's patent, finding it non-obvious. On first glance, this case is complicated, with complex technology, multiple parties, an appeal and a cross-appeal, and a variety of issues raised in both. But on closer inspection, the core issue is actually quite simple. The patent in this case covers the forms of administration of an antipsychotic drug, and in particular claims a rapid disintegration form of that drug and administration of that drug under the tongue or sublingual, or between the cheeks and the gum. The parties agree that this antipsychotic drug itself was well known in the art. They also agree that it was known that at least some drugs could be given in rapid disintegration forms or administered under the tongue or between the cheeks and the gum. The core question in dispute is whether it would have been obvious, whether a person of skill in the field would have had a reason to use these forms of administration with this particular antipsychotic drug. On appeal, the generic drug companies argue that this test is made, that there would be such a motivation, because doctors would have wanted other forms of administration for this antipsychotic drug. They further argue that administration under the tongue or between the cheeks and the gum or in rapid disintegration form would have enhanced patient compliance among a population, those with psychiatric conditions, who might otherwise be unwilling to swallow pills or might spit out the pills. On the other hand, Forrest, the brand drug company, argues that this patent is non-obvious because the inventors here recognized a previously unknown problem. That IV administration of this antipsychotic drug or the administration in a pill form could cause cardiac incidents. And that the inventors further recognized that, the rapid disintegration form or administering under the tongue or between the cheeks and the gum eliminated these cardiac incidents. According to Forrest, we still don't know why these forms of administration eliminate the cardiac incidents, and that in any event, all of this shows that the patent was non-obvious. In addition to this core issue, there's some additional issues raised on appeal, including whether one of the claims even requires these forms of administration, and whether the patent's written description covers the full scope of the claims. Likewise, Forrest's cross-appeal challenges the district court's judgment of non-infringement as to one claim for 2 of the generic companies on the ground that those generic companies don't mark their labels with the uses claimed within the patent claim, in particular use for schizophrenia. And so that's the core dispute in our first case, Forrest versus Sigmapharm.
The Kerr versus MSPB case stands out like a sore thumb on the panel because it involves an employee action. And the Federal Circuit does have exclusive jurisdiction over some types of claims that arise out of employment in federal agencies. In this case, there was a manager in the Fish and Wildlife Service who sued for retaliation and for discrimination and was constructively resigned from her job. The issue for employees is whether to take a civil rights action directly to federal court or to take some claims, agency claims such as whistleblower claims before the agency itself. So there arises a kind of mixed claim. You have some claims that can go before the agency and some claims that can go before the court. So a procedural morass arises, and this was a situation that Ms. Kerr found herself in. She took the claim first to the 2006 to the MSPB. The MSPB said, you don't have a final claim yet, go back to the agency. She went back to the agency, received a final claim, and then decided to take both a whistleblower and a Title VII claim to the federal court. Then ensued a nightmare. She went back and forth between the district court and the Ninth Circuit on whether or not she could vindicate the civil rights claim and the whistleblower claim in the federal courts. She ultimately lost on the civil rights claim, and then the court said, after reversing itself, it said she could not bring the whistleblower claim before the federal courts. So at that time, she then went back to the MSPB and said, look, I couldn't bring my claim in the federal courts. I now want to pursue this claim that I originally filed in 2006. And there was a delay of over 8 years. The agency then said, sorry, you're too late. You didn't have reason to delay, and there's no good cause to excuse your delay. She, of course, has now appealed to the Federal Circuit, which reviews the MSPB on some kind of deferential standard on the basis of this isn't fair. There was good cause to excuse my delay. I was trying to vindicate my rights in federal court. So the issues before the Federal Circuit will be whether she had good cause to excuse the delay, and she says she did because of then prevailing circuit court precedent, or alternatively, whether instead an equitable tolling standard should apply, which the agency rejects, saying there should be no automatic tolling of the time period she tried to raise the claims in federal court. So this is a procedural case. It's kind of a mess, but it'll give you a very different insight on some of the complicated jurisdictional issues that can arise when one type of claim, an employee violation, could be vindicated again either in the agency or into the courts, and what happens if you split them up.
In our third case, Rehco versus Spinmaster, the parties had a prior business relationship regarding the design and supply of radio-controlled toy helicopters. Ultimately, that business relationship broke down, and now Rehco is suing Spinmaster for breach of contract and patent infringement related to those toy helicopters. The U.S. District Court for the Northern District of Illinois here in Chicago granted summary judgment in favor of Spinmaster on both claims. The dispute in the breach of contract claim comes down to whether a specific product, the Havoc Heli, was included within the release granted at the time of a resolution of a prior royalty dispute and a prior audit of the royalties paid by Spinmaster to Rehco. According to Spinmaster, the claim as to the Havoc Heli existed at the time of the release and was in fact part of the audit because it was included in an early draft of the audit before subsequently being deleted by Rehco. To Spinmaster, this means it falls within the precise scope of the release, which granted a release as to claims related to the audit and claims that existed at the time of the release agreement. On the other hand, Rehco contends that the Havoc Heli was not included within the release because the release was limited to the scope of the audit, and the scope of the audit was defined by a list of specific product SKUs, of which the Havoc Heli was not one. Turning to the patent infringement dispute, it raises three distinct issues on appeal. First, somewhat amusingly, but not unusually for patent cases, there's a dispute over the meaning of the word A. Rehco points to the term, to the general patent proposition that the word A means one or more. It's not limited to the singular. And therefore, the claim term, a said signal, can cover Spinmaster's accused products, which use multiple signals. Spinmaster, on the other hand, contends that the general proposition that A is plural is rebutted here because it is used consistently throughout the patent in the singular form, and therefore its products with multiple signals are excluded from the scope of the claims. Second, the district court found, and Spinmaster defends that judgment on appeal, that the claims are limited to a binary system by which the helicopter is always moving up or down depending on whether a signal is received or not. And Spinmaster contends that its accused products use a proportional system that is constantly making adjustments to maintain a set height. Rehco, on the other hand, contends that this difference between binary and proportional systems is completely irrelevant to the claim language, and that in any event, the district court improperly ignored evidence at the summary judgment stage that would have shown that the accused products meet this requirement. Third, and finally, in terms of the infringement issues, is the question of the doctrine of equivalence, which would allow Rehco to prove infringement even though the accused products are not exactly the same as that claimed in the patent, if they are insubstantially different. Rehco again contends that the district court ignored evidence improperly at the summary judgment stage that would have shown that the insubstantial difference between the accused products and the claims. Spinmaster, on the other hand, contends that Rehco's doctrine of equivalence arguments were simply conclusory and not sufficient to prevent summary judgment. Our final case, Spineology versus Wright Medical, is probably the most straightforward of the 4 cases that we have for the Federal Circuit, raising a single isolated issue. In a prior appeal, the Federal Circuit had affirmed the District Court's grant of summary judgment of non-infringement in favor of Wright Medical. In this appeal, Wright Medical challenges the District Court's denial of its motion for attorney's fees. Section 285 of the Patent Act allows a district court to award attorney fees to a prevailing party in exceptional cases. And the Supreme Court has defined exceptional cases to be those that stand out from others in terms of the substantive strength of a party's litigating position or the way in which the case was litigated. According to Wright Medical, this case meets that standard for exceptional case because Spineology's infringement theory for this patent related to a specific device used in orthopedic surgery rested on an interpretation of the patent claims that had no support in the patent itself or in the case law. Further, Wright Medical says, Spineology continued to pursue its infringement theory even after the district court rejected this claim interpretation and thereby foreclosed infringement. And finally, Wright Medical says, Spineology's damages theory lack any support in the case law. The problem for Wright Medical is that the Supreme Court has also emphasized that the award of attorney's fees in the finding of an exceptional case is committed to the sound discretion of the district court. And Wright Medical needs to have the Federal Circuit overturn the district court's denial of those attorney's fees and denial of a finding of exceptional case. Spineology says that the abuse of discretion standard required to overturn the district court's conclusion is not satisfied here because it was reasonable for Spineology to assert infringement against Wright Medical when Wright Medical copied its commercial product, and that further, the district court never finally resolved the claim interpretation issue until it ultimately granted the summary judgment decision that was the subject of the first appeal. And finally, Spineology contends that its damages theory are legally and evidentially supportable, and therefore there's no exceptional case on that grounds.